Legal issues. In this presentation, there is some legal information which is not legal advice. I am not an attorney. I've been educated by experienced attorneys, and I have researched legal opinions and court conclusions as the basis for my interpretations. I believe that my interpretations and recommendations are beneficial for the generalized situations described herein. Always get legal advice from your own attorney according to your situation. Legal issues. The equitable mortgage. Number 1. The equitable mortgage issue. Many misinformed judges have created flawed case law in my humble, not legal opinion, due to ignorance of the doctrine of equitable conversion. A lease with option to buy that has applied monthly rent credit that reduces the final balance owing seems to look like a mortgage loan, often called an equitable mortgage, because there is no written mortgage document, which is a security instrument recorded on the property title to secure the repayment of a loan. The reasoning is that the initial option consideration is applied to reduce the purchase price, which is like a down payment, and then the applied monthly rent credits reduce the balance owing at exercise, which is like an amortizing loan. And then the final balance owing must be paid in full, which is like a balloon payment. If it looks like a duck, waddles like a duck, and quacks like a duck, then it's a duck. How do you like that for reasoned legal principles and respecting contract law? The judge deems the transaction as an equitable mortgage, and thus the landlord cannot evict the tenant for non-payment of rent, because the tenant is really an owner and must be foreclosed with a judicial foreclosure action, like a contract for deed, CFD. This only happens in residential real estate. There is no written mortgage or deed of trust. Thus, a judicial action is required to foreclose the implied CFD by creating a contract that is contrary to what the parties originally intended and memorialized in writing. Robin Hood sitting on the bench. Commercial real estate is about contracts. Residential real estate is about people. Dolph DeRoos, real estate investor. The doctrine of equitable conversion states that equitable interests in the asset are converted, that is, exchanged between parties, when a non-contingent executory contract is signed by both buyer and seller as a purchase and sale agreement, PSA. The seller's equitable interest in the asset is transferred from the seller to the buyer, and the buyer's equitable interest in the funds, notes, or other property to pay for the asset is transferred from the buyer to the seller. This conceptually happens exactly when the PSA is fully signed and becomes executory or executed, that is, when the parties are fully committed to completing the transaction. This does not happen for a contingent contract when there remain conditions precedent to the contract becoming executory or executed. Therefore, an option contract represents merely a contractual interest in the underlying asset and not an equitable interest, because the option is merely a contract to hold open an offer to buy or sell under certain pricing and payment parameters for a specific time period, exactly like a PSA that is signed only by one party that is bound by specific performance to complete the transaction upon countersigning the contract by the other party and cannot withdraw the contract before acceptance. The initial option consideration is like a non-refundable earnest money deposit, EMD, to compensate the effective optionor, the party who signed the PSA, for accepting the risk and burden of specific performance. There can be no exchange of equitable interest until the option contract is exercised and creates an executory contract. An unexercised option is the same status as before the counterparty signs the PSA. Thus, an unexercised option contract cannot exchange equitable interest because a non-countersigned PSA is not executory. Until the option is exercised, that is, the PSA is countersigned, the optionee cannot offer a security instrument against the property title to secure a loan without having equitable interest in the property. An option contract for realty attaches a PSA that is notarized only by the optionor. The optionee countersigns the PSA to exercise the option, thus creating an executory contract. An option contract for personalty has an assignment agreement. Number 2, the sandwich lease option issue. This is very similar to the equitable mortgage issue. An investor signs a lease with option with the owner and then offers another lease with option to a tenant buyer. The problem is that the investor has no equitable interest in the property and therefore cannot offer to a third party an option to buy that property. The simple solution is to offer to the tenant buyer an option to buy the option contract, which is personal property, that the investor holds with the owner. The tenant buyer exercises the option by signing the attached assignment agreement and now owns the investor's option contract with the owner and then exercises that option to buy the property by signing the attached purchase and sale agreement, the PSA, as the buyer and then closing the transaction. See the real estate licensing issue about assigning a PSA or an option contract. In most states, there are no licensing issues with assigning contracts. In some states, like Illinois, licensing is required to assign a PSA or an option contract. Legal issues, licensing. Real estate licensing, assignments. Important. This topic requires legal advice from your attorney according to your specific situation. Different judges may interpret differently the same law. In general, you will not need to be licensed when you are a principal party to the transactions in this presentation. However, some state legislatures, such as Illinois, have capitulated to the high-pressure lobbying efforts of the Realtor Association special interest groups to suppress competition, and thus enacted legislation to require a real estate license when you engage more than once per year in a business pattern of dealing in contracts or options for realty. You cannot delegate to retaining the services of a real estate licensee. When closing as an original signatory party to the realty contract or option, you are exempt from licensing because you are not dealing, that is, buying, selling, exchanging, in realty contracts or options. This affects wholesalers as which you are effectively operating when your intent is to assign your contractual position to an unrelated third party. You must pay a tax to realtors for your surviving the risks to earn a living by your own efforts by obtaining a real estate license. Legal issues, achieving the effect of assignment without licensing. Illinois Statute Excerpt of Public Act 101-0357, Section 1-10. Whether for another or themselves, engages in a pattern of business of buying, selling, offering to buy or sell, marketing or sale exchanging, or otherwise dealing in contracts, including assignable contracts, for the purchase or sale of, or buys, sells, offers to buy or sell, or otherwise deals in options on real estate or improvements thereon. For purposes of this definition, an individual or entity will be found to have engaged in a pattern of business if the individual or entity by itself or with any combination of other individuals or entities, whether as partners or common owners in another entity, has engaged in one or more of these practices on 2 or more occasions in any 12-month period. Your real estate attorney must advise you about your situation regarding how to achieve the same effect as assignment, because you cannot simply retain the services of a real estate licensee. Be careful. If it looks like a duck and quacks like a duck, then it's a duck. Judges grant themselves wide interpreting latitude. The penalty for operating without a license is $25,000 maximum per incident. Realtors don't want competition from the free market. The intent is to convey legal control and close in the original signatory name specified on the contract. Your intended assignee pays a fee to the optionor, that is, the seller, for a backup option contract under the same parameters as your existing option contract. And then the optionor simultaneously pays that fee to you as a termination fee to cancel your primary option contract. Then the backup option contract is automatically promoted to first position in the transaction with your intended assignee as the original optionee, rather than as an assignee. A similar transaction may operate with a backup contract for a lease agreement or a PSA, so that the optionor and the intended assignee are the original principal parties named in the replacement contract, and the previous contract is terminated, that is, never completed or closed. The intent is to convey legal control and close in the original signatory name specified on the contract. Use a new Illinois-type land trust, also called a revocable grantor trust. The trustee, not you, signs the contract, and then you assign your beneficial interest of the trust, which is personalty, to your intended assignee. Your assignee now controls the trust, and thus controls the contract with the trust name as the original principal party. Each trust must have a unique trustee name. The intent is to convey legal control and close in the original signatory name specified on the contract. A new limited liability company, LLC, is created as a principal party to sign the contract, and the membership interests of the LLC are assigned to an unrelated third party. The LLC remains the original principal party name specified on the contract and is now controlled by the assignee. Each new LLC must have a unique general manager signatory. The intent is to convey legal control and close in the original signatory name specified on the contract. Use an option to buy an option contract, which is an option contract to buy personalty. Your name is not on the realty contract or option. Step number 1. The optionor signs PSA. The counter-signature line is blank. Step number 2. Attach the PSA to the option to buy realty contract. Step number 3. The optionor signs the option contract. The counter-signature line is blank. Step number 4. Attach the option to buy realty to the option to buy an option contract. Then the parties both sign the option to buy an option executory contract, which is assignable without a license because it is for personalty, not realty. An assignment agreement conveys the personalty ownership of the option to buy an option executory contract to the new optionee. The option to buy an option contract is executed, that is completed, by the then current optionee by countersigning the option to buy realty contract. The option to buy realty contract is now executory with original signatures. The optionee can countersign the attached PSA to exercise as an original signatory. In Illinois or any other state that requires licensing for assignments of realty paper, you may decide that the easiest path to enter or stay in business is to obtain a real estate license. Licensing is a serious decision because there are issues for holding a real estate license. Licensing requires many hours of expensive initial education and formal testing. You must carry personal insurance for errors and omissions coverage because you cannot use a liability shield such as a corporation or limited liability company, an LLC. Every year you must pay fees and successfully pass continuing education courses. For the first few years, you must earn experience by hanging your license under the supervision of an employing broker, who will take a significant percentage of your commissions and control what transactions you are allowed. If you cannot find a broker to allow you to deal in realty contracts and options, then you are out of the contract assignment business until you can qualify for your own independent broker license. To have access to the Multiple Listing Service, MLS, you must become a member of the political special interest groups of the Realtor Associations. You must pay fees for membership to the MLS services and to all of the associations that own those MLS services that you need, and to the National Association of Realtors. Fees on top of fees. Realtors caused the 2008 meltdown by failing their duty to protect their clients. Without question. Legal issues, Dodd-Frank legislation. Many real estate gurus are misinformed of the Dodd-Frank federal legislation. Thus, they are misinforming their students about the compliance issues. The Dodd-Frank legislation as it pertains to seller financing applies only to selling a 1 to 4 dwelling unit residential property to an owner-occupant buyer. A non-owner-occupant buyer is exempt. This means that you can buy with seller financing without a residential mortgage loan originator, RMLO, license, unless the state has statutes requiring the RMLO license. The lease with option, when the payment has an applied monthly rent credit, or when the option includes seller financing for exercising the option, also must comply with the legislation. No rent credit and no seller financing for exercising the option, that is, the buyer must cash out the seller, is exempt. Always check with your attorney about such requirements because the laws and regulations often change. Dodd-Frank exemptions for owners offering seller financing to owner-occupants. Exemptions apply when selling to an owner-occupant buyer, a consumer, and number 1, the seller is selling one property in any 12-month period, and all of these conditions are true. The seller is a natural person. The seller did not construct the property. Do not attempt to exchange your property with another builder's property and then offer seller financing. The financing has a fixed rate and does not adjust for the first 5 years. The borrower has a reasonable ability to repay ATR certification for the loan. No negative amortization, that is, deficit interest. Or point number 2, the seller is selling 3 properties in any 12-month period, and all of these conditions are true. The seller is a corporation, LLC, partnership, trust, estate, etc., a legal entity. The seller did not construct the property. No shenanigans with exchanges between builders. The financing has a fixed rate and does not adjust for the first 5 years. No negative amortization, that is, deficit interest. The borrower has a reasonable ability to repay the loan. No balloon payment. Don't even think about jacking up the interest rate after 5 years to force the debtor to refinance the loan. The exemptions are intended to obviate the need for a seller to obtain a residential mortgage loan originator RMLO license or to retain the services of an RMLO to qualify the buyer. Non-exempt transactions require the RMLO. If you are conveying the property to a non-owner occupant, such as selling to a landlord, then the RMLO is not required. The legislation intends to protect financially illiterate owner-occupant residential buyers. As a business operator, you will not qualify for the seller exemptions without the RMLO to sell the home to an owner-occupant buyer. Therefore, the buyer must retain the services of the RMLO to qualify as an owner-occupant for the ability to repay and to provide the required disclosures for the financing parameters. The buyer pays the RMLO service fee. Legal issues. In this presentation, there is some legal information which is not legal advice. I am not an attorney. I've been educated by experienced attorneys, and I have researched legal opinions and court conclusions as the basis for my interpretations. I believe that my interpretations and recommendations are beneficial for the generalized situations described herein. Always get legal advice from your own attorney according to your situation.